Laws of Arrest, online prepared by DPS, Law Enforcement Academy, Santa Fe, New Mexico. Goals: students will appreciate the power and responsibility in their ability to make an arrest. Students will recognize the potential for abuse under the laws of arrest. Students will learn how to apply laws and procedures under New Mexico law. Objectives: upon completion of this course, students will be able to define reasonable suspicion and probable cause. Know what is needed to stop someone. Know what is needed in order to frisk someone. Describe what is involved in an investigatory detention. Know the differences in making a misdemeanor and a felony arrest. List the misdemeanor offenses when an officer can make an arrest although the offense did not occur in his or her presence. Know when to get an arrest warrant. Explain how location, defendant's home or another, can affect serving an arrest warrant. Know what consular notification is. Know when the community caretaker exception applies in a vehicle stop situation. Explain what is involved in a DWI checkpoint. Learn the laws of vehicle stops. Sources: New Mexico Criminal and Traffic Manual. New Mexico Statutes Annotated. State and federal case law. Estimated time 7 hours. May go longer because topics often discussed in search and seizure are included. Prepared by Legal Instructor, Department of Public Safety, Law Enforcement Academy, Santa Fe, New Mexico. Date: approved ________________________ accreditation number _______________________________________________________________________. Laws of Arrest. In part I will discuss the following: 1. Introduction to Laws of Arrest. 2. Reasonable suspicion and probable cause. 3. What is needed to stop someone? 4. What is needed to frisk someone? 5. What is needed to arrest someone? 6. Issues involving an arrest. In part 2 we'll discuss the following: 1. What is needed to do a vehicle stop? 2. Issues involving a vehicle stop. Laws of Arrest. Part I. Introduction. People familiar with the criminal justice system often comment on the tremendous power of judges and ADAs. ADAs can indict people. Judges can sentence people to long periods in jail or prison. And yet ADAs and judges will tell you that it is the police officer who has an awesome responsibility. It is the police officer and only the police officer who has the discretion to stop or not stop someone, to detain or not detain someone, to arrest or not to arrest. We must remember that an arrest, no matter how small the offense, results in the loss of an individual's personal freedom. We must never forget that it is the power given to us out of community trust and is not to be abused or seen as the sole solution in every situation. Arrest defined the taking of a person into custody to answer for a crime. To arrest is to deprive a person of his or her liberty by legal authority. Constitutional foundations of arrest. The primary amendment is the Fourth Amendment. It is the Search and Seizure Amendment, which also refers to seizing people. The right of the people to be secure in their persons shall not be violated. The word persons refers to stops, detention, and arrests. The Fifth Amendment: no person shall be deprived of life, liberty, or property without due process of law. The term liberty refers to arrest. We are going to discuss and try to understand the following questions: what is needed to stop someone? What is needed to frisk someone? What is involved in an investigatory detention? What is needed to arrest someone? What is needed to do a vehicle stop? We will be looking for legal answers to these questions. To answer them, however, we need to understand and define legal terms such as reasonable suspicion and probable cause. Law enforcement, lawyers, and the general public are all familiar with these terms. Unfortunately, it is difficult to come to a common agreement as to what these terms mean. Reasonable suspicion and probable cause. What is reasonable suspicion? What is probable cause? What is the difference between the two? It's difficult to explain. That's because reasonable suspicion and probable cause, like many legal terms, mean different things to different people. An example may be the best way to clarify and understand reasonable suspicion and probable cause. Suppose it is 2 o'clock in the morning and we're in a classroom. We're in a high crime area. There is a business across the street. It can be any kind of business, but this one sells televisions and DVDs and so forth. The business is now closed. No suspicion. We look outside the window and see a young man walking through the parking lot in front of the store. The parking lot in front of the store is well lit. Would you run out and stop the young man? Would you demand ID? Would you arrest him for concealing ID if he refused to give you ID? Answer: an officer can question the young man and ask for ID. But the officer cannot stop, detain, the young man unless he or she has reasonable suspicion. The young man may refuse to provide ID. If we don't have reasonable suspicion to detain him, we cannot arrest him for concealing ID. Reasonable suspicion. It's still 2:00 in the morning. You look outside and see a car in the well-lit parking lot. A young man is standing beside the car. The business alarm has just gone off. You notice a broken window in front of the business. Do we have enough reasonable suspicion to detain this person? Yes, to stop someone, to investigate, to stop someone to the point they're not free to leave. We need more than a hunch or a gut feeling. We need a reasonable suspicion that a crime has occurred, is occurring, or is about to occur. We're suspicious, of course. But it's not enough to say this looks suspicious. Is our suspicion reasonable? We need to articulate our reasons for thinking so. 2:00 in the morning. Business closed. Broken window. Man walking away is the only person in the parking lot. Alarm is going off. Answer: we have enough reasonable suspicion to stop this individual. At this point we do not have enough probable cause to arrest him. A simple, common-sense definition of reasonable suspicion: you're suspicious and it's reasonable that this person has done a crime or is involved in a crime. Probable cause: we have sufficient reasonable suspicion to detain this person. To arrest someone, we need more, we need probable cause. We now will try to understand probable cause by continuing with this scenario. After a backup officer detains the subject, an officer might approach the crime scene investigation in the following way. Business: you notice fresh blood on the windowsill. You look inside the business and note that no one is inside. You see a row of boxes of TV sets. In the middle of the row, one TV box is missing. There appears to be torn clothing by the broken glass. Vehicle: inside the nearby vehicle you see a box similar to the row of boxes in the business. You run the license plate and it comes back to John Smith. John Smith lives on the other side of town. You notice some fresh blood on the door handle. The person appears to be nervous and sweating. It's a cool night. The person has fresh blood on his hands. His clothing is torn and appears to match the torn clothing by the broken window. The person gives you his ID. His name is John Smith. He says he is looking for a friend's house but doesn't know where he lives. The person has conflicting stories about the TV set in the back seat of his vehicle. Given the above factors, is there enough probable cause to arrest this person? Yes, a simple common-sense definition of probable cause: a crime has been or is being committed and this person probably did it. The important word is probably. This person more likely than not did this crime. There appears to be sufficient probable cause to arrest this individual. Another difference between reasonable suspicion and probable cause. Reasonable suspicion is when an officer arrives at a crime scene. Probable cause is when an officer leaves the crime scene. Going to trial requires a higher standard, beyond a reasonable doubt. For example, we may need to get fingerprints from the subject, the broken window, and the TV set. We may want to compare blood of the subject, the door handle, and the TV set. The following chart gives legal requirements for officers: police, citizen encounter, stop, pat down, investigatory arrest, detention. No Fourth Amendment. Need officer can always reasonable probable approach a citizen, suspicion cause person is armed, police citizen encounter if a citizen is free to leave. The Fourth Amendment does not apply. A police officer can always approach and talk to a citizen. But when officers stop people, when they're not free to leave, the Fourth Amendment kicks in and we have to follow court guidelines. We will discuss what happens in the following order: stop, pat down, investigatory detention, arrest. What is needed to stop someone?